46 people versus Isiah Williams, 2355 FC.
Sorry. Let me grab it. Oh.
Okay, what do we have today? Counsel, your appearances?
Good afternoon, Your Honor. Danielle Russo-Bennett on behalf of the people.
Good afternoon, Alex Pearson on behalf of the people.
Okay.
And good afternoon, Your Honor. Daniel Woodson on behalf of Mr. Williams, who is appearing via Zoom.
All right, Mr. Williams, can you hear us?
Yes, Your Honor.
Okay, today's the date and time set for pretrial in this matter. I will just kind of on the record say that the last time we were in court, the defendant requested to represent himself. At that time, we had a brief conference with Ms. Woodson, who said she felt that she had a good relationship with him, at least as far as whatever. So I don't know where that stands today. So that's a question. And then I also need to either inform the defendant or Ms. Woodson that there are some motions that have been filed, or at least the motion hearing dates. So they need to be kind of finalized. It's not, I mean, no one's arguing the motions today, but we got to finalize that. So Ms. Woodson, what's your understanding of what's happening today?
Your Honor, the court has to answer the question about whether or not the court is going to allow Mr. Williams to represent himself. He did instruct me to not respond to the motions on his behalf because he wants to represent himself. Although I do have a good relationship with Mr. Williams, I have talked to him. It's my understanding he has represented himself previously in other legal proceedings. He's very insistent on representing himself here. I understand the court may have some concerns about a layperson representing themselves, especially with these charges. So I don't mind being standby counsel. I explained to Mr. Williams that may happen, and if that happens, I'll basically be following what he wants. But, you know, because he's not a lawyer, the court may decide that a lawyer needs to be appointed in advisory capacity. But he is ready, willing, and able to represent himself. There was an issue of competency at the district court level. He did come back competent. I don't have any questions regarding his competency, so I leave it to the court to make the decision.
Okay. I don't know that you really get to weigh in on this, but I'm certainly happy to hear from you.
Judge, I do just want to raise some concerns because we did address this already at the district court levels, and I have been in court with Mr. Williams for a couple of years now and have seen some really disturbing, concerning behaviors that really, to me, I would be remiss if I didn't put that on the record, that I have significant concerns about him representing himself. And I, being cognizant of what the Constitution is and what the case law says, we did address this with Judge Simpson, and Mr. Williams started to exhibit some understanding and then some clear misunderstandings. And then at one point even said he didn't want to represent himself. He just didn't want his attorney anymore after he had already fired one attorney. So that really caused Judge Simpson some concern that he didn't really want to represent himself. And one of the issues we raised at the preliminary exam is, even if you get to represent yourself, there's case law, People v. Daniels, and there's a rule of evidence that says you don't get to cross-examine, you don't get to question the victims. Your attorney, your standby attorney, will get you the victims or the other acts victims. And that's where things kind of really spiraled and fell apart in district court. And then, much like Mr. Williams tends to do every time we would have a hearing in district court, when he didn't like what he was hearing, he did not like the very first witness who was testifying, the deceased mother was testifying. He immediately became disruptive, became combative, and then demanded that he be taken in the back and got into a shouting match with Judge Simpson. And so he had to be ordered and yelled at and screamed at to sit back down. He does not listen. He has said on the record that he will object to absolutely everything. So I'm concerned that while he needs to be held to what an attorney would be held to, he's not going to. And I don't know that we'll ever effectively get through any proceedings, because I think his goal is to simply disrupt the proceedings. I think Ms. Woodson is right. He has been representing himself since the 60s on cases. That comes from his family as well, saying he gets in trouble, he picks up a new case, he represents himself. But he's never had a case of this magnitude. Say nobody, 41-year-old cold case homicide. And the court saw what I filed already. We've already had an expert witness testify on this. There's a 65-page brief on the other acts. And I think that This is a really extensive, complicated case, and I'm concerned about that. And so the second day of preliminary exam, he simply refused to come out. And we had to wire up the back so that he could watch his preliminary exam, to which he appeared to sleep throughout it. And so my concern is that he does this for show, and he is going to do what he can to disrupt the proceedings, as opposed to be held accountable just like an attorney would. And I know that Ms. Woodson would be there as an advisory attorney and would be there to work with him. But I'm still concerned that what happened at preliminary exam when he was told no will continue throughout these proceedings. I think this is going to be a very lengthy trial. There are a large number of other witnesses that have extensive years of abuse with this man. There are many elderly witnesses in this case, and I am concerned that if he's to represent himself, he will be harassing and he will cause undue embarrassment and harassment to these witnesses. I understand what the law says. I understand what the position that the court is in. But if I don't make that record, I'm afraid that we will find ourselves months down the road dealing with the behavioral issues that we've seen with Mr. Williams.
And, I appreciate that. I can't really prejudge him in the sense that he hasn't behaved that way in front of me. So to the extent, Mr. Williams, is it your request today that you represent yourself in this and until further order of the court?
Yes, Your Honor. I
Okay.
would love to take a stand forth. The Holy Spirit have invited me to stand. I am a spiritual individual, and I believe to be obedient unto the word of God.
So let me interrupt you, because there's some things that I have to put on the record regarding this. So the authority for the court to allow you to represent yourself in a felony criminal matter comes from MCR 6.005 subsection D. So I have to ask you some questions. First of all, you understand the maximum penalty for the charged offense, which is homicide, open murder, is life imprisonment. You understand that?
I'm fully aware of that, Your Honor.
All right. And that there additionally would be DNA identification profiling samples taken. Understand that?
I didn't understand what that last part you said. That identify.
All right. It means that they're going to take some DNA samples from you.
Oh, they
for
did that already,
future
Your Honor.
cross-checking. So that's another penalty according to the maximum on the charge. Do you understand that?
Yes, they had taken the DNA sample of me, but they didn't take one of the biological father.
Okay. Sir, self-representation is almost always unwise, and you may conduct a defense ultimately that's going to harm you, that's to your detriment. You understand that I'm advising you that this is not a good idea.
I understand, Your Honor, and I'm willing to allow the court to take and bring forth anything that they feel is necessary within this matter. I don't have any qualms with it.
All right. You're entitled to and will receive no special indulgence by me. You got to follow all the technical rules of substantive law, procedure, and evidence in the making of motions, objections, the presentation of evidence, voir dire, and argument. So I want to be clear that the same rules that govern an attorney will govern and control and restrict you. So you're going to have to abide by all the same rules that all the lawyers in this room took years to learn. So you understand that, correct?
Yes, Your Honor, I truly do.
Okay, you're going to receive no more library privileges than those available to any other unrepresented party, meaning that you don't get extra time for preparation, you don't get any staff or investigators at your disposal. That comes from a case in Michigan under People v. Blunt, 189 Mishap 643, 1991. So I'm just kind of reaffirming that you're under the same obligations that the lawyers are. And because you don't have a lawyer, you don't get more time, or I don't waive, the requirements for you. Do you understand that?
Yes, I will, though, will I be able to use the library at the Washington County Jail?
You get to use the library as you're available to use it, but you don't get to just say, hey, I'm representing myself and I'm going to go to the library 24 hours a day.
Oh.
Whatever your restrictions are on using the library, they remain the same. You can use it when you can use it, but you can't use it extra because you're representing yourself.
I fully understand. Thank you, Your Honor.
All right. The prosecutor is an experienced professional attorney. There are actually two of them who will give you no break or quarter because you don't have the same skills or experience. In other words, they're not going to take it easy on you because you're not a licensed attorney. Do you understand that?
Yes, Your Honor.
All right. And if you can't afford to hire your own attorney, I will represent someone else to represent you. If you can hire an attorney, I'd give you some time to do that. Do you want me to give you a little bit of time to find another lawyer, or do you want me to appoint somebody else, or do you want to represent yourself?
I would love to take and represent myself as far as an attorney, employing my own attorney. I would ask that the court would order that they release my $10,000 check to me that they withheld on October the 12th, that they've been had in their custody, and they claim they don't have my money in seed, but my $10,000 check have not showed up. And
well, I personally don't have that check, so I don't know what you're talking about, but I can't order anything like that. But what I can tell you is that I will grant your request and I will allow you to represent yourself. I am going to keep Ms. Woodson as your standby counsel. I know she's explained that to you. So she's going to give you some insight and advice and help you. She's going to be present during the proceedings if you need her and you need her to speak on your behalf. And as you heard the prosecutor say, you cannot cross-examine victims or certain types of witnesses in this case. So she will have to step in on some of those occasions. So you understand that?
I would definitely do not want, you understand, Ms. Wilson to work and on my behalf in no shape, no form, because I have already decided to take and file a suit against her in the court, a motion for illegal, you understand, attorney, as you understand, illegal, inadequate. And so I don't really want her.
I don't necessarily agree on any inadequacy, so I'm not going to go into that right now. Is there a conflict with the public defender in this case?
He had the public defender. He fired Mr. Feaster when we first started this case. This was his second appointed attorney.
Okay, I didn't know which order, but I'm not the first attorney of record, Your Honor.
I knew that.
Yeah, the public. There was no conflict, but he. I'm not sure what existed or what happened. But once he fired Mr. Feaster, Ms. Woodson was appointed after that.
And I think there was some months or almost a year before.
I did not hire her.
You gotta understand something, Mr. Williams. Let's not have this go sideways this early in our relationship. You are allowed to represent yourself, but you must have a lawyer who is what's called standby counsel. Ms. Woodson explained to me that she explained that to you, and the prosecutor also put on the record that there are certain things that you may not do. So you have to have a lawyer representing you. So I'm either going to A, appoint Ms. Woodson as your standby counsel. B, I'm going to go back to the public defender. I don't know why I allowed them to withdraw, but it wasn't because of a conflict. So I'm going to appoint the public defender to be your standby counsel. You have to have that. So if that's not acceptable to you, then we're going on to the next stage of how this is going to go. So it's your choice right now. Do you want Ms. Woodson to be your standby counsel, or do you want the public defender to be?
No, I do not want Ms. Wilson no way in my behalf, because I find her to be incompetent.
Well, that is
Okay.
I don't, but okay. You don't need to go any further. I will allow her with, I'm appointing the public defender to represent you in the standby concept. Okay? That's what you're asking me to do, right?
You're saying that you would take and go to the public defender and find a standby counsel on my behalf. Is that correct?
Yep, I'm appointing public defender to be your standby counsel, and the public defender's office will assign an attorney to this. You don't get to pick it. So I'm telling you that. So it's your choice. Ms. Woodson or public defender, your call.
I would have to go with since I have no other courts, because I can't deal with Mrs. Wilson. I would definitely have to go with the public defender, because she
Enough said. enough
Yes.
said. I will appoint the Washtenaw County Public Defender to be your standby counsel. So
So much, Your Honor.
I don't know if that's Ms. Wilson or Ms. Woodson.
Ms. Woods.
All right, so Ms. Woodson, I am going to,
But for if his lawsuit is Ms. Wilson.
right, I'm gonna order Rawl as his attorney of record, as well as not obligate you to be standby counsel in this matter. I am appointing Washtenaw County Public Defender, the standby counsel. Mr. Williams, let me offer you something else. At each proceeding, I'm going to ask you questions about whether you want to continue to represent yourself. If you do, then the answer is yes, and I'm going to keep reminding you that, you know, it's not a good idea and that you should have a lawyer. But if you continue to say yes and we don't have difficulties with your behavior, then I'm going to allow you to continue to represent yourself with the standby counsel. But I'm going to ask you at each hearing how that's going to go. But because you are currently representing yourself, I am going to require that, well, let me ask you, Ms. Woodson, before you leave today, have you had a chance to share with him the motions that have been filed?
I told him about them, but I have not been able to print it out and physically bring it to him.
All right, so I'm going to ask you before you are discharged to deliver a set of all pending motions to Mr. Williams. So, Mr. Williams, Ms. Woodson or Wilson's final act in your case, she's going to deliver all the papers that are pending. So the prosecutors in this case have filed some motions. I am requiring that you file your answers to those motions on or before September 6th. So that's approximately 3 weeks or so from today's date. And I'm going to order that the prosecutors may schedule those motion hearings anytime, motion of Wednesday, actually after the 6th, because I need them. So he has until the 6th to file his responses. You can file for the first available or whenever you'd like to schedule them after the 6th of
Should
September.
I wait until after Mr. Williams files his response? Okay. I will be in trial for 2 weeks in September in front of Judge Slay, so let's.
Literally
after.
file them whenever you want them heard, but your order is to file your responses by September 6th, 2023, all right?
Your Honor, should I forward a copy to the defender's office?
Yes, please.
Okay,
Yep.
I'll do that.
All right.
Your Honor, will you also please ask if the prosecutor office will finally provide me with a motion for discovery that's been over a year that has been filed for a copy of the full.
If you have filed a motion, you
Yes.
need to file a motion for me to do it. This is what I mean. You don't get just to blurt out requests. You are held to the same standard. So if the prosecutor is not doing something they're supposed to do, you need to file a motion and schedule it for hearing, and I will absolutely hear what you have to say. But I also have the right to read everything before we come to court so that I know what you're talking about and I know what they're talking about. So if you want me to consider that, you got to file it, notice it, send them a copy, and we'll be prepared because she'll file a response.
Thank
Okay.
you. Thank you.
Okay. So there's no court hearing pending at this point until you file your notices for those hearings. But you're going to get those motions and you got to file your responses before September 6th. Okay?
Also. Now.
All right.
Also, would there
Thank
be
you.
a chance for your court to determine if gotten a bond? Because I've not been able to provide a bond since my incarceration.
Right, same deal. You got to file a motion, they get to respond to it, and I will consider it. But we don't just have a conversation when you're on Zoom. I have no idea what you're saying, what you're talking about. I'm not Judge Simpson. I wasn't in those hearings. I have no idea. So you don't get to just ask me to do stuff from the jail. You file your paperwork, and I will absolutely give you the respect you're due, but I have to know what you're talking about. I can't just do stuff sitting here.
Oh, I
All right.
understand, Your Honor.
All right, so you can file what you need to, and I will be happy to hear it, okay?
Thank you.
All right,
Thank
thank you. That concludes the hearing.
Thank you, Your Honor.
you. You have a blessed day and the peace of God be with you and your family.
Well, I guess what I'll do is I'm going to adjourn the pretrial without a date right now. When you file your motion hearing, when we get a date from the prosecutor, that will be our next pretrial date and we'll see what we need to do next.
Okay.
Thank you, Judge.
Thank you.
Have a great day, everyone.
Yes, thank you.
Oh my God.
And last but not least, all right.